On the show today, we're going to talk about cyberbullying. Is cyberbullying an offense in Uganda? Do the Ugandan laws recognize cyberbullying as an offense? What happens or what should happen, and what is the legal system surrounding the offense of cyberbullying? What happens to the perpetrator and what happens to the victim? Can the victim report the matter to the police, or where should the victim report the matter to? What happens to the perpetrator, the bully, and what do the laws recommend should happen to the bully? What is the entire legal framework of Ugandan laws in regards to dealing and managing with cyberbullying? If you want to know the answers to all these questions, stick around because I'm going to address them. Hi everyone, my name is Nagarev Joanne and welcome to the Ask Me About the Law YouTube channel. So Ask Me About the Law YouTube channel is an edition of Ask Me About the Law podcast, which is available anywhere you get your podcast from Google Podcasts to Apple Podcasts, Spotify. And Ask Me About the Law podcast is also an edition of Ask Me About the Law blog, which is available at www.kevejoanne.com, which I'll also leave in the description box under this video. So I'll leave a link to the podcast in the description box of this video. I'll also leave a link to the blogs still in the description box. So at Ask Me About the Law, we have free and honest conversations about the law. We have conversations every Sunday at 7 p.m. Remember to watch out on the blog, on the podcast, and now on YouTube. And we always look forward to talking to you guys every time you reach out to us via comments on our social media handles or DM. So the handles on all social media platforms, that is Facebook, Twitter, Instagram, Snapchat, is at Ask Me About the Law. We're also on LinkedIn, by the way, so kindly leave us those questions. But first things first, you need to know that on August 30th, 2019 U report concluded that among U reporters aged 15 to 24, 40% of them from across the country confirmed that they had been victims of cyberbullying, and they emphasized that the cyberbullying they faced happened mainly on Facebook. So for purposes of this video, I need us to know and put into consideration that cyberbullying and bullying are two very distinctive things. For purposes of this video, we are going to define cyberbullying according to the definition maintained by the UK National Bullying Helpline against cyberbullying, which defines cyberbullying as any bullying, harassment through technology, including trolling, mobbing, grooming, or any form of abuse with the intent of causing another, who's the victim, any harm, distress, or personal loss. So the main emphasis here is to remember that it has to be conducted virtually or via any cyber means. So something that is done through the internet, through SMSs, through laptop devices or gadgets is what we would define for the purposes of this video as cyberbullying. Case in point, in the UK in 2019, Kelly was among the first victims in the UK system to be held liable for committing the offense of cyberbullying. Kelly commented on her wall, her personal Facebook page, comments to her victim saying that she would kill her. Now, when the matter was taken before court, Kelly was convicted and sentenced to 3 months in prison for her comments, which she emphasized that she would kill her victim. This was despite the fact that Kelly had taken her comments down off her Facebook page. Nonetheless, the recently enacted Computer Misuse Act may provide a solution to this problem. See, the Computer Misuse Act provides for two offenses that bear splitting resemblance to the definition maintained by the UK site on cyberbullying. One is the offense of cyber harassment, and the second one is the offense of offensive communication. Section 24 of the Computer Misuse Act creates the offense of cyber harassment, which it defines as the use of a computer to make obscene requests or threatening to inflict injury to any person or their property. The modes of communication that are recognized under the offense of cyber harassment include email, blogs, chat rooms, instant messaging services, electronic bulletin boards, and social networking site. This is Facebook, Twitter, Instagram, Snapchat, whatever. Provided it is a social media site, it qualifies as a mode of communications recognized under Section 24 of the Computer Misuse Act. In addition to that, Section 25 of the newly enacted Computer Misuse Act also provides for the offense of offensive communication, which bears resemblance to the definition maintained by the UK government handling and managing cyberbullying. And I quote, Section 25 of the Computer Misuse Act defines the offense of offensive communication as the willful and repeated use of electronic communication to disturb the peace, quiet, or right of privacy of any person with no purpose or legitimate communication, and as such amounting to violating their privacy. The essence of the establishment of the offense of offensive communication is that, as provided for under the Constitution of the Republic of Uganda, every Ugandan is guaranteed the right to privacy. Whereas this right to privacy is not absolute, meaning that where legally provided for, the legal system recognizes if that right can be violated, especially for the greater good or in benefit of the greater majority. However, if you haven't done anything as a Ugandan to warranty or have that right violated, then as a Ugandan, you are mandated and protected under the Constitution of the Republic of Uganda to have a right to privacy, especially on your digital platforms. So, the major emphasis provided for under Section 25 of the Computer Misuse Act, which establishes the offense of offensive communication, it has two specific requirements that need to be met for the alleged activity to amount to offensive communication. One, the perpetrator conducting the communication to you needs to conduct the communication or the communication has to be of an offensive nature. And then the second thing is that the perpetrator need not have legitimate reason to communicate to you. And finally is that the offensive communication has to happen repeatedly. So what this means is that one-off communications do not qualify to amount to offensive communication, and that two, you have to be offended by that offensive communication, or it has to qualify as amounting to an offense for it to qualify under the offense of offensive communication. However, I want you to know that because of the vagueness of this provision, you need to understand that amounting to offensive is very subjective. See, what may be offensive to me or what I may find offensive may not necessarily be offensive to you. National Female Youth MP one Ms. Anne Adeke complained of a stalker who allegedly sent unsolicited messages, which in her opinion she defined as violating her peace and privacy. Another situation was in 2009 when one James Omara was convicted on his own plea for allegedly sending repeated phone text messages to a member of parliament, Ms. Catherine, for violating her peace and privacy. Unfortunately, whereas these ladies defined these actions as amounting to offensive communication and as such violating their peace and privacy, however, what was happening in the media and in the newspapers was rather the opposite. If anything, large percentage of the country were mocking the ladies for defining what happened to them as offensive communication. If anything, a large percentage of the Ugandan population through the media was alleging that it was something that was very basic and should have been swept under the rug. So because it doesn't set a benchmark of what exactly is or can be qualified as offensive communication, this has created a lot of restriction and friction in application of this provision. And in fact, the courts have been very vocal about it and emphasized that Section 25 is rather very vague. This is because the legal system likes working in an environment which is rather precise and direct to the point. So because these provisions are very vague, in mainly Section 25, because it doesn't set the benchmark of what is offensive communication, it has created a lot of friction in its application. For example, the recent case between Uganda versus Dr. Stella Nyanzi The court emphasized and held that the provisions, section 24 and 25, were rather too vague, and because of their vagueness, they amounted to a violation of Dr. Stella Nyanzi's constitutional right protected by the laws of Uganda that warranty that one needs to know extensively the type and nature of the offense they have committed. The essence is that if one knows exactly the ingredients or what amounts to the offense they have committed, then they can raise a proper defense which will amount to them participating in a free and fair trial. What this means is that one needs to be held accountable before the Ugandan legal system and the Ugandan courts of law by specifically having the offense defined under the laws of Uganda of what they have committed. See, if one knows exactly what offense they have committed, i.e., the ingredients of what amounts to that offense they have committed, then they can raise a proper defense accordingly to address the alleged actions or the alleged offense they have committed. That is what the Ugandan legal system defines as amounting to one of the proper provisions of amounting to a free and fair trial. See, Uganda is not the only country struggling with the enactment of the offense of cyberbullying. This is because cyberbullying is directly intertwined with the right to freedom of speech, expression, and the right to privacy. In the People of the State of New York versus McQueen of 2014, the New York Court of Appeals struck down the Albany County law that criminalized the offense of cyberbullying, declaring that it amounted to restriction of freedom of speech and expression. However, the dissenting opinion before this honorable court emphasized that whereas the definition of the offense of cyberbullying was rather vague and very broad and overbearing, however, it still maintains that Albany County had a constitutional right to prohibit any communications that had no legitimate purpose and were a violation of one's privacy and were intended to create and inflict emotional harm on children. If you'd like to know more about what Ugandan laws say about the right to freedom of speech and freedom of expression, please check down under this YouTube video. I've left a link to a blog where I address extensively what is freedom of speech under the Ugandan laws and what the Ugandan laws say about freedom of speech. Alternatively, victims of cyberbullying can seek redress using the Penal Code laws of Uganda, which provide for the offenses of libel and also defamatory statements. Section 180 of the Penal Code laws of Uganda defines defamatory matter to mean any matter which is likely to injure the reputation of any person by exposing that person to hatred, contempt, or ridicule, or likely to damage any of that person's professional character or trade, or injure their reputation in any form. It also further establishes that it is immaterial whether at the time of the publication of the alleged defamatory matter of that person, that whether the person is dead or still alive. That means regardless of whether the matter is filed before a person passes away or when the person is still alive, the matter can still be heard before court. The provision further emphasizes that no prosecution for the publication of defamatory matter concerning a dead person shall be instituted unless the DPP's office approves of the matter. Section 181 of the Penal Code laws of Uganda also further emphasizes and endeavors to define what publication is. It states that publication of information that may be defined as libel is if the information is printed, written, painted, or published in any other form, and it is conveyed to be dealt with either by exhibition, reading, reciting, description, delivery, or otherwise, that can amount to defamatory matter, provided it can be used by any member of society to relate it to and associate it to the victim. So this means that whereas the bully may not endeavor to definitively define their victim in their defamatory comments or publications. However, if any reasonable member of society endeavors and makes the connection between the published defamatory content with an individual in society, then that is enough to qualify as amounting to defamatory matter. In fact, in the case of Nsababuturo versus Munansi, when the court was deliberating in regarding to what amounted to defamatory statements, the plaintiff Nsababuturo proved to the court that the defendant's actions amounted to defamation of his character, and as such, the court awarded the plaintiff Nsababuturo damages for the defendant's action. In Shaw versus Uganda, the court refused the alleged perpetrator's defense of stating that since they had not definitively stated the victim's name specifically in their comments, therefore they were alleging that what they communicated and published and redistributed cannot amount to defamatory statements. In fact, the court emphasized that if any reasonable member of society can use that published content to make a relation and a connection between the victim of defamatory statements with the defamatory content distributed, then the author of that defamatory statement can be held liable for publishing defamatory statements. So what this means is that if person A makes a comment or authors a comment on Facebook or a post on Facebook, whereas they may not directly state their victim's name on their Facebook post, however, if someone in the comment section makes the connection between the content allegedly published on the Facebook page with any individual in society, then that person, the author of the Facebook post, can be held liable for publishing defamatory statements on their Facebook post. This also means that if person C reads the Facebook post with allegedly defamatory statements and redistributes the defamatory statements to person D, and when they're redistributing that statement, they also quote or tag someone identifying that victim, then they can be held liable for redistributing defamatory statements. In addition to that, the court further emphasized that if anyone that participates in the distribution of content does not take the initiative to endeavor to understand how factual the content they're sharing is, then they can be held liable for publishing defamatory statements. What this means is that if one does not take due diligence to clarify, understand, factualize whatever they are sharing, then they cannot raise a defense that they did not know what they were doing was wrong. Meaning that if the information is reshared by any other third party, what the third party cannot claim that they were ignorant of how true or false the information is, because it is the law gives you the responsibility to ensure that whatever you're sharing is factual. So you may want to be very cautious the next time you share any information and endeavor to take due diligence to ensure that the information you're sharing is factual. On a side note, you need to remember that for one to claim or seek using the offense of defamatory statements, one needs to make sure that the information being shared about them is actually wrong and not true. What this means is that if someone posts information about you and it's true, then you cannot claim that you are being defamed because the information being shared about you is true. However, if you prove to the court that the information being shared about you is wrong, this then will amount to you using what we call defamatory statements, because the information being shared about you is wrong. Therefore, it's amounting to injury of your reputation in society. Other jurisdictions have also acknowledged that cyberbullying comes in very many forms. It can be cyber harassment, it can be cyber stalking, it can be also revenge porn. Thankfully, the Computer Misuse Act recognizes the offense of cyber stalking. In particular, Section 26 of the Computer Misuse Act states that any person who willfully and maliciously repeatedly uses electronic communication to harass another person and makes threats with the intent to place that person in reasonable fear for his or her safety or to any member of that person's immediate family commits the crime of cyber stalking and is liable on conviction to a fine not exceeding 120 currency points or imprisonment not exceeding 5 years, or both the 120 currency points and imprisonment not exceeding 5 years. However, in Uganda, rather than rehabilitate victims of cyberbullying through the release of revenge porn, which has arguably, considering the recent years, been one of the most prominent forms of cyberbullying on the internet in Uganda. So rather than rehabilitate the victims, the government and the law and the legal system has unfortunately weaponized the Anti-Pornography Act of 2014 to villainize the victims of revenge porn. In 2016, when Ms. Judith Hard's nude pictures were released the second time through revenge porn on social media, she said she contemplated committing suicide because she emphasized that she was being blackmailed by someone who accessed her phone, and because she failed to pay the ransom, the nude pictures were released. But rather than the government and the laws of Uganda endeavoring to rehabilitate the victims, it instead indicted her on grounds of production and distribution of pornographic material as provided for under the Anti-Pornography Act. Cyberbullying in Uganda is not recognized as an offense. If anything, there aren't any tailored specific laws to tackle directly the offense of cyberbullying. However, Uganda's legal system has various provisions that can be carefully tailored to deal with the issue. You have been watching the Ask Me About the Law YouTube channel, which is a place where we have free and honest conversations about the laws in Uganda. If you enjoyed listening to this YouTube video, please leave it a thumbs up and also share it with your friends and family. If you have any comments and suggestions, you can leave them in the comment section down below. I look forward to reading through your comments and replying. If you also enjoyed this video and would like to see more videos like this, please like this page, like this YouTube channel, and also click on the notification bell so that you are notified every time I release new videos, which is every week on Sunday at 7 p.m. Remember to share these videos with your friends and family. Remember, Ask Me About the Law YouTube channel is an addition of Ask Me About the Law podcast, which I'm going to put the links to the other podcast directories in this under this video in the description box, so check it out. We're available on Spotify, SoundCloud. We're also available on Apple Podcast or wherever you get your podcasts from. I'm going to leave all the links to other podcast directories under this video in the description box. Also, if you'd like to read the blog, which is very well detailed and extensive, I recommend you read it. I'm going to leave the link to the blog in the description box down below. If you want to follow me on other social media platforms, I'm also going to leave the links down below in the description box. If you'd like to reach out to me for any comments, suggestions, don't forget, description box down below. Leave the comment. I always endeavor to answer your messages. Thank you very much.